are at University Copyright Advisory Services and Vice Chair of the LIBER Copyright Working Group. Madam, once again, 6 minutes, please.
Thank you. Here, thank you. So, I represent research organizations and libraries, and we are very pleased with the draft report. The research community creates also the startups and the spin-offs, and also for university cooperation and for the welfare of Europe, we welcome that it is outside the research organizations in the draft. Text and data mining is desperately needed by everybody in the European Union, and if you go to where the Commission starts from the Lisbon Treaty, there is clearly said that research is not just for universities. Research is meant for innovation and for the economic growth of Europe. And with the draft, we have that. So great thanks to the rapporteur. It's really going in the right direction, as Professor said. Then I have one comment, because in the Article 2, you have the definitions. And the definition for a person is lacking. I think this is the most important piece of legislation drafted in my lifetime, and I've done copyright law since '94, and those who know my family have done copyright law. My family has done copyright law for 100 years, so this is the most important piece of legislation, and this is right, because the rapporteur said that a person means legal entities, private entities, public entities, and so this is right, but it has to be added into the definitions in Article 2, but this is a technical thing, and the ITRE rapporteur, who says public entities, private entities, has it right, so this is a technical thing. Then, as the professor said, there is no protection for information, there's no protection for data. Only specific intellectual property rights are created, such as patent for inventions, and then the reproduction right for data and for the sui generis database right. So those are the only things we have to think about. And as Professor said, actually the use of works and sui generis database, they are also very narrowly defined rights. So for the most of text and data mining, there is no problem. Like he said, keep calm and keep text and data mining. There is no legal protection anywhere for information and for knowledge, and this is what the democracy and research and everything we respect is based on. There is freedom of knowledge, freedom of information. So this has to be kept in mind, and we have to make sure that the whole of European Union is not just made to lift publishers that are having problems with the digitalization and the new right, normalization of data. I'm really a bit worried about that, but in general, that article is very good to add also that in top of when you define the person, as rapporteur has defined, the person is public entities and private entities, then having additionally the new right for that kind of content that universities have already bought, but they are not given right to text and data mine by publishers, by unfair agreements from publishers. So this is really great, but it has to be defined in the recitals or in the article that there is no protection for data or information. And then gets it right, I think, the balance with researchers and research organizations and publishers. So that was, I think, what I wanted to say. And the right to mine is the right to read today. There's a wonderful renaissance. I see it at the university, at the campus, at the startup, at our SLUS event in Helsinki, which is the biggest startup event in Europe. And we have to allow this renaissance. And the rapporteur, thank you, thank you, thank you. You allow it by allowing this to startups and to other private entities. So thank you very much.
Thank you as well, Madam. Now the floor goes to Mr.